You're under arrest, okay?
What?
You have the right to remain silent. Anything you do or say can be used, what's the next part?
As a flotation device.
As a flotation device.
You have the right to remain silent. All of your statement will be used as evidence against you in the court of law. You have the right to consult with a lawyer and have the lawyer present with you during the interrogation. If you cannot afford a lawyer may be appointed to represent you at no cost. This phrase or this statement may be familiar to you. Maybe you heard it in the news or you heard it in a movie or any television. It is called Miranda warnings. What is Miranda Doctrine? It all started with this guy, Ernesto Miranda. In 1966, Ernesto Miranda was accused of the crimes kidnapping and rape. He was detained by the police and chose not to have a lawyer while interrogated for 2 hours, where he confessed that he committed the crimes accused to him. Before arresting, Ernesto wasn't advised of his right to remain silent. At the trial, his confession was admitted by the jury, convicting him for the crimes committed and sentenced him 20-30 years imprisonment. After 2 years, Ernesto Miranda appealed his conviction, stating that he was not advised of his right to remain silent and his statement should not be used against him. The Fifth Amendment of the United States Constitution states that no person shall be compelled in any criminal case to be a witness of himself, nor be deprived of life or property without due process of law. And the Sixth Amendment of the United States Constitution states that in all criminal prosecution, the accused shall enjoy the right to a speedy and public trial by an impartial jury and have the assistance of the counsel for his defense. And lastly, in 1963, the Supreme Court had ruled in Gideon v. Wainwright that the state must provide a lawyer to any defendant who cannot afford one. Although Ernesto Miranda provided a written confession acknowledging that his statement during the interrogation could be used against him, the question is, could it be used against him as he was not informed of his right prior to making that statement? In 1966, the Supreme Court took up that case, and Miranda's conviction was overturned by a 5-4 majority. The court found that the interrogation environment had been designed and was intimidating to Ernesto Miranda, placing him under the will of the police. The court ruled there can be no doubt that the Fifth Amendment privileges is available outside of the criminal proceedings, and thus the Miranda warning was born. Ernesto Miranda was paroled in 1972. After his release, he started selling autographed Miranda warning cards for $1.50, just like celebrity. Over the next few years, Ernesto Miranda was again arrested for numerous crimes, and because he violated his parole, he was sent back again to Arizona State Prison for 1 year. On January 31, 1976, after his release for violating his parole, a fight broke out in a bar in Phoenix, Arizona. Ernesto Miranda was there, and unfortunately, Ernesto Miranda received a lethal wound from a knife, and he died along with his Miranda warning cards. The Miranda warnings came to the Philippines, and it is included in our 1987 Philippine Constitution. It is found in Article 3, Section 11, Republic Act No. 7438. It is an act defining rights of person arrested, detained, or under custodial investigation, as well as the duties of the arresting, detaining, and investigation officers, and providing penalties for violation thereof. In Section 2, Paragraph B, the Republic Act No. 7438, it states there that any public officer or employee or anyone acting under his order or his place who arrests, detains, or investigates any person for the commission of an offense shall inform the latter in any language known to and understood by him. It means that you can say the Miranda warnings in Tagalog of his rights to remain silent and to have competent and independent counsel, preferably of his own choice, who shall at all times be allowed to confer privately with the person arrested, detained, or under custodial investigation. If such person cannot afford the services of his own counsel, he must be provided with a competent and independent counsel by the investigation officer. So what is the importance of Miranda warnings? If the police officers fail to advise the Miranda warnings before arresting, the statement of the accused will be not used as direct evidence against him in the court. Moreover, if the police officers uncover additional evidences such as murder weapon or guns as the result of your statement, it will be not used against him in the court as evidence. It is considered as contaminated evidence because you did not, or the police officer failed to advise him of his rights. And that's it for today. Thank you guys for watching. I hope you enjoy. I hope you enjoy so much. Thank you for watching. I hope you learned something. Thank you guys. Bye bye.